A court ruling just dropped that could reshape what legal carry looks like for millions of Americans. And here's the part almost nobody is talking about. Most gun owners won't hear about it until after someone gets arrested, charged, and forced to fight a case that could follow them for years. Before we go any further, ask yourself one honest question. Are you staying up to date on how fast gun laws are changing? Because what I'm about to break down isn't just a headline. It's a shift in how courts analyze carry bans, how states defend restrictions, and how ordinary people can get caught in the middle of legal confusion. Let's slow this down and explain it in plain English. A federal appeals court reviewed California's rules on open carry. Specifically, it looked at how the state restricted open carry in counties with populations over 200,000 people. In practical terms, that population cutoff covered the major metro counties, where most Californians actually live. The court said the state can't block open carry that way. Now pause. That does not mean open carry is now legal everywhere. It does not mean you can strap on a handgun tomorrow morning and assume nothing can happen to you. Court rulings don't flip reality like a light switch. They move the battlefield. They trigger appeals. They create uncertainty. They force states to respond, and uncertainty is where people get into trouble. The case centers on California's so-called urban open carry ban. The rule used a population threshold. If your county had more than 200,000 residents, open carry was essentially off the table for ordinary citizens. That meant the right technically existed in some rural counties, but disappeared in the places where the vast majority of people lived. The appeals court panel examined that structure under the framework established by the U.S. Supreme Court in New York State Rifle and Pistol Association versus Bruen. Under that decision, courts evaluating Second Amendment challenges must look to historical tradition. Governments can't just argue that a restriction promotes public safety. They must show that similar regulations existed in American history and were widely accepted. And that's where the pressure hit California's population-based open carry ban. The judges essentially said, you can't eliminate a common method of carry across huge areas where most people live without strong historical justification. That single principle creates 7 major shifts, not just in California, but potentially nationwide. Let's walk through them carefully. Change number 1. Large geographic open carry bans just became much harder to defend. For decades, some states relied on geography as a limiting tool. Instead of banning open carry everywhere, they carved out large urban zones and said, not here. On paper, they could argue the right still existed. In reality, it disappeared for most residents. Under the reasoning influenced by District of Columbia versus Heller and reinforced in New York State Rifle and Pistol Association versus Bruen, the focus is no longer on modern policy preferences. It's on historical analogs. States now have to answer a tougher question. Was there a widespread historical tradition of banning open carry in heavily populated areas simply because they were populated? That is a much narrower lane to drive in. If courts consistently apply this reasoning, it doesn't just affect California. It gives attorneys in other states a blueprint to challenge similar large-scale geographic restrictions. Change number 2. Open carry and concealed carry are being treated as distinct constitutional categories. Many people assume this logic. If the state allows concealed carry permits, it can ban open carry without constitutional concern. That argument has been common for years, but the panel's reasoning suggests something different. Open carry isn't just a stylistic preference. It can be treated as its own protected mode of bearing arms. Why does that matter? Because states often build restrictions on trade-offs. We'll prohibit this form of carry, but allow that form. If courts require independent historical justification for each type of restriction, those trade-offs become harder to sustain. It means lawmakers can't simply say, you can hide it, so we can forbid you from showing it. They must demonstrate that banning open carry in broad regions aligns with historical practice. Change number 3. Legal on paper is no longer automatically acceptable if it's impossible in practice. Here's where things get subtle. Some jurisdictions technically allow carry-through permits. But the application process is complex, delayed, or functionally inaccessible. When courts examine these systems under the Bruen framework, they may look beyond the statute's text to how it operates in real life. If a right exists only in theory, buried under bureaucracy or geography, that becomes relevant. This shift pushes courts to ask, what does the law actually do to ordinary people? Does it preserve the right in a meaningful way, or does it extinguish it across the places where life actually happens? Change number 4. Fear-based justifications carry less weight without historical backing. States frequently argue that open carry causes alarm, confusion, or panic. Those arguments may resonate politically, but under the historical tradition test, fear alone is not enough. The state must show that similar broad restrictions were part of the American legal tradition. That forces governments to argue like historians rather than policymakers. It narrows the conversation to evidence, not emotion. Change number 5. Sensitive place expansions could face increased scrutiny. After the Supreme Court's decisions in District of Columbia vs. Heller and New York State Rifle and Pistol Association vs. Bruen, several states expanded lists of so-called sensitive places where carry is prohibited. If courts are skeptical of broad geographic elimination of carry rights, attorneys may argue that extremely expansive sensitive place designations create the same functional result, a right that exists on paper but nowhere in daily life. That doesn't mean every sensitive place law falls. It means courts may ask harder questions about scope and historical grounding. Change number 6. Population cutoffs and patchwork systems look more vulnerable. Using population numbers to shrink constitutional rights is now under sharper judicial examination. If a right disappears exactly where most people live, courts may view that as constitutionally suspect. Other states with county-based variations or population thresholds may need to reevaluate their frameworks to avoid similar challenges. Change number 7. The real fight may be just beginning. A 3-judge panel decision is not always the final word. The state can seek rehearing by a larger panel, en banc. It can petition the U.S. Supreme Court. Enforcement may be paused during appeals. This is critical. The legal landscape during an appeal can be confusing. A ruling may exist, but not yet control day-to-day enforcement in the way people assume. And that is where ordinary citizens face risk. If you carry, you need to understand the difference between a headline and a settled legal reality. Now let's talk about practical mindset. Not legal advice, but common sense caution. First, don't rely on social media summaries for current law. Updates move fast. Appeals change timelines. Context matters. Second, watch official state guidance and court orders. An appeal can pause implementation. Third, understand that even if you ultimately prevail in court, the process itself can be expensive, stressful, and life-disrupting. Fourth, avoid assuming that one federal circuit's ruling automatically changes the rules nationwide. Federal appeals decisions bind courts within their circuit. Elsewhere, they are persuasive, but not controlling. The broader theme here is bigger than one state. Gun law is now shaped heavily by litigation. Legislatures pass statutes. Courts evaluate them under historical analysis. States respond with new laws. Lawsuits follow. It's a dynamic cycle. Under District of Columbia vs. Heller, the Supreme Court confirmed an individual right to possess firearms for lawful purposes such as self-defense. Under New York State Rifle and Pistol Association vs. Bruen, the court established a history-focused test for evaluating restrictions on public carry. Those decisions reshaped Second Amendment litigation nationwide. The recent federal appeals ruling builds on that framework. It signals that broad elimination of open carry across densely populated counties requires more than modern policy arguments. But here's the part many people miss. When courts strike down one approach, states often adapt. They revise statutes. They refine definitions. They expand certain categories while narrowing others. Legal landscapes rarely stay static. So what should a responsible gun owner take away from this? 1. Understand that constitutional rights are enforced through courts and that enforcement evolves. 2. Recognize that clarity may take time. Appeals can stretch months or years. 3. Prioritize caution. Even if you believe you're correct under a recent ruling, local enforcement practices may lag behind court developments. 4. If you have a specific situation or plan to change how you carry, consult a qualified attorney licensed in your state. Individual facts matter. This is educational information, not legal advice. Laws vary by jurisdiction and can change rapidly depending on ongoing litigation. The big picture is this. A federal appeals court said a state cannot wipe out open carry across the areas where most people live merely by drawing population lines. That is a significant development. It strengthens challenges to large-scale geographic bans. It reinforces the historical tradition test. It pressures lawmakers to justify restrictions with evidence rooted in American legal history. But it also triggers appeals, uncertainty, and strategic legislative responses. The Second Amendment debate is increasingly fought in courtrooms, shaped by precedents like District of Columbia versus Heller and New York State Rifle and Pistol Association versus Bruen. Each new appellate ruling becomes part of that evolving map. If you own firearms or care about carry laws, the most important habit isn't reacting emotionally to headlines. It's staying informed, understanding the procedural posture of cases, and recognizing that the law can be a moving target until the highest courts settle the question. And until that dust settles, caution, awareness, and reliable legal guidance remain your best tools for staying out of trouble.